On a rainy Thursday night in San Diego, Melissa Carter stood outside her own rental property, staring at a stranger through the front window. The woman inside was laughing, barefoot, holding a wine glass like she owned the place. Melissa's key no longer worked. She knocked once, hard. A man she had never seen before opened the door halfway and frowned. "Can I help you?" Melissa felt her stomach drop. "This is my property. Where's Evan?" The man looked confused. "Evan. He rented us the apartment for 6 weeks. That was the moment everything changed." Evan Mercer had been Melissa's tenant for 11 months. Quiet, clean, always polite. The kind of tenant landlords hoped for in California. But standing there in the cold, with 2 strangers living inside the unit she had leased to him, Melissa realized Evan had done something he had never asked permission to do. He had sublet the apartment, and he had done it behind her back. Inside, the strangers showed her payment receipts, messages, and a listing Evan had posted online. Furnished, flexible stay, prime location. They had paid thousands up front. Melissa's hands trembled as she scrolled through the messages. Evan had turned her long-term rental into his own private business, and under his lease, that was forbidden. She drove home in silence, then opened the signed agreement from her files and read the clause again. No assignment or subletting without prior written consent of landlord. Clear, simple, unmistakable. The next morning, Evan finally answered her call. He sounded annoyed, not ashamed. "It's temporary," he said. "I'm still paying rent, aren't I?" Melissa's voice turned sharp. "You leased out my property to strangers without my permission. They're harmless," Evan replied. "You're overreacting." That sentence made the decision for her. By Monday, Melissa had spoken to a landlord-tenant attorney. The lawyer reviewed the lease, the screenshots, the receipts, and the listing. Then he said the words Melissa needed to hear. "This is a lease violation. If the tenancy is covered, proper notice matters first. But unauthorized subletting can absolutely become the basis for an eviction case in California." Evan was served with a 3-day notice to perform covenant or quit. The notice gave him a choice: fix the violation or give back possession. Instead of fixing the problem, Evan doubled down. He sent Melissa a smug email claiming she had no case because he had not stopped paying rent. He even accused her of harassment. Then Melissa discovered something worse. One of the occupants had already invited another person to stay there. Her property was slipping further out of control. 3 days passed. Evan did not remove the subtenants. He did not surrender the unit. He did not negotiate. So Melissa filed an unlawful detainer action. What Evan had treated like a clever side hustle was now a real court case. The hearing was set quickly, just as these cases often are. On the morning of trial, Evan arrived in a dark blazer, carrying himself with the confidence of someone who still believed this was all a misunderstanding. Melissa sat beside her attorney, tense but composed. When the judge entered, the room fell silent. Melissa testified first. She explained how she discovered strangers in the unit, how her key had failed, how she found the listing, and how Evan had accepted money from occupants without ever informing her. Her attorney introduced the lease, the no subletting clause, screenshots of the online advertisement, payment records from the occupants, and Evan's email admitting the arrangement was temporary. Evan's lawyer tried to soften the damage. "My client did not abandon the premises," he argued. He continued paying rent. There was no financial loss to the landlord. But the judge's expression did not change. Melissa's attorney stood for rebuttal. "This case is not about late rent," he said. "It is about possession and control. The lease expressly prohibited subletting without written consent. The tenant ignored that clause, monetized the property, placed unknown occupants in the unit, and refused to cure after notice. That is a material breach." Then came the testimony that hurt Evan most. One of the short-term occupants took the stand and confirmed that Evan had presented himself as fully authorized to rent the place out. She said she assumed he either owned the property or had permission to act like he did. The courtroom grew still. Evan finally testified in his own defense. He admitted he had listed the property. He admitted he never requested written permission. He admitted he collected money. But he insisted it was common sense, that Melissa should not care, as long as rent was paid. The judge leaned forward. "That is not how contracts work," she said. The words landed like a hammer. In her ruling, the judge explained that a residential lease is not just about monthly payment. It is also about who has the legal right to occupy the property. A tenant cannot rewrite that arrangement in secret, simply because it becomes profitable. Evan had violated a material term of the lease. Melissa had served notice. He had failed to cure. Judgment for possession was entered in Melissa's favor. Evan lost the apartment. Outside the courthouse, he stood alone at the bottom of the steps, staring at the papers in his hand, as if they belonged to someone else. Melissa did not celebrate. She only breathed. Because for weeks, she had watched a stranger's gamble unfold inside something she had worked years to buy. And now, finally, the law had drawn the line. In California, this kind of mistake can become a legal disaster very fast. If a lease forbids subletting without written consent, violating that clause can support a 3-day notice to perform covenant or quit. And if the tenant refuses to fix the violation, the landlord can then file an unlawful detainer case. California's tenant protection framework also treats assigning or subletting in violation of the lease as an at-fault just cause in covered tenancies. That means paying rent on time does not erase every breach. Under the law, permission matters, possession matters, and the written contract still matters most.